Yeah, thank you, Judy. This is Sam Wampler. I'm going to be your moderator today, and welcome to the program. As some of you may know me, some of you may not. I've been retired from Bricker and Eckler for the last 8 years and haven't been very active in the legal community. And other than through the CBA, I do still go to committee meetings and stay in touch with people. But I was introduced to the EDR concept last winter up at the Shumaker office in Toledo in a 2-day, a very detailed presentation and very excellent presentation Peter Silverman put on with others at Shumaker, and it was just great. And I think you'll realize as we go through it, and maybe you've read some of the materials already, that this is a great concept, and it's a work in progress, kind of like everything we do is a work in progress, why they call it practice. And we hopefully get better at it as we go. I mentioned to Peter before we started that there were a couple of things that woke up this morning this program. One was that, the shortest distance between 2 points is a straight line. And for those of us that have litigated cases through to a verdict or a court judgment, know that there's no straight line to that. EDR is a sincere effort to provide a construct within which people can work to straighten that line out somewhat and get things resolved early on. Another thing came to mind was had a law professor tell me once that he and his wife were both lawyers, and they get in an argument. All she wanted to do was win, and all he wanted to do was be right. And you have lawyers or clients like that sometimes, and that's a very expensive proposition, because in either case you're going to turn over every rock. You're going to be obstructive if you want to win. Sometimes you're going to be obstructive if you want to be right. You're going to turn over every rock, and they're again very expensive for the client. So if you think about those things as we go through this program today, I think you'll realize how this process offers another, what I think is a very effective tool for the parties to get a dispute behind them as soon as possible. And with that, I'm going to turn it over to Peter briefly.
Okay, so this first slide is just a short introduction. So you understand just basically what it is we're talking about, because we're going to give a lot of background first. First, it's a lot of information. So we present this in a 2-day training, which we did last December, and we were set to do those nationally this year, and they were going to start in June. The AAA has embraced the concept, and we were going to do it at AAA headquarters in New York in June, and then we were going to take it around to actually certify people. And then COVID hit, so we're not doing the 2-day trainings, but we might do it through video. I'm looking at that option. And at some point, we'll be resuming that. If you want to follow it and see if there will be training, you can see at the bottom of your screen, there's a URL for the EDR Institute, and we have all kinds of information on that website, and we'll have scheduling on it. Both Sam, well, all three, Mike, Marcus, and Sam all took the training. There were about 40 lawyers from all over the country, maybe 10 corporate counsel and 30 lawyers. Some were neutrals, some were advocates. And so it's an exciting idea that's been around quite a while, but we really just finalized it and put it into formal form last summer. Just so you understand the general way it would work, it's supposed to be a 30-day program. There's no magic in the 30 days, but you do an initial dispute assessment, which we'll discuss. That's more than just figuring out the basics. And there's information exchange, which is if either party needs information to value the case, there's a process for that. Then there's objective dispute valuation. So what Sam said about, if you want to win or if you need to be right, you're going to have a biased look at the case, or you're going to go all kinds of ways. Objective dispute valuation tries to make it objective. And then final resolution is when you negotiate based on that. There's some other things we deal with on that. All of this is embodied in protocols. So we have the protocols are on the website. They're quite detailed and try to deal and anticipate with all the issues that might come up. And we'll be discussing some of them here. But if you read through them, they are very self-explanatory.
Okay, so what you're going to be hearing today are these four areas to, first of all, open your mind and think about this. This is a new concept. I'm sure that everyone out there has had a lot of thoughts that brought all this process together, but now it's been packaged. So open your mind to it and just think about a new way of doing things. There are some key concepts that'll be covered. As Peter just mentioned, there are the 4 steps that are followed, and then the skills, which we'll cover at the end, are perhaps a little more, I'll say, dense and complicated. But as you work through them, they make sense. And there's probably nothing you're going to hear today that you haven't done on some level. That would be my guess. But this is a very structured process, and if those sides buy into it, it can be very good for the clients. So next slide. We're going to start off with open your mind. Now, if you would, if you want, in your chat box, you can list reasons why it's not feasible to resolve most disputes in 30 days. Just go ahead and put that in your chat box, and just type along. You don't have to be exhaustive, but if you think of a few things, if they come to mind, put them in there. I would imagine we're going to end up with quite a few diverse reasons. And then at the end of the presentation today, we're going to take questions, and we're also going to address some of the issues that come up in your comments. So feel free to chat away on this. I think if you have questions that come up, you can use the Q&A, and we'll address those at the appropriate time. Sometimes a question may come up that will be answered later, so you won't get a quick response. But anyway, with that, I think we have Mike is going to start off with the
that's it.
With why 30-day EDR isn't feasible.
Yeah, and so I saw a chat come up, and I didn't get a chance to look at those, but it'll be interesting what people say. So, Peter and others have created a list of these issues that we've heard that it's not feasible, and it's interesting to sit through the training last year and hear some of these, because there's another one that'll add to this list that came up there. But one is legal profession inertia. We're kind of stuck in our ways, and nobody can really comprehend the concept of trying to settle something in 30 days from when a dispute arises, or 30, 45. Again, Peter's, there's no magic to that time period. The other is, how do you do something like this without discovery and the rules of civil procedure? We need written discovery, we need interrogatories, depositions, requests for admissions. We have to pour through every last document to make sure we're not missing anything. Greedy litigators. If we settle these cases fast, we'll probably shrink our fees substantially. So instead of making several $100,000 on a huge piece of litigation, it may be a fraction of that. The doormat syndrome, that's the fear that people have, that if you broach settlement too early at the beginning of a process, they think that you're somebody that can be walked all over or that you've got something to hide. There's the 30-day question. Who in the world can do anything in 30 days? Most of us don't even respond to complaints in 30 days. We ask for the automatic extension. The legal profession inertia, that's kind of I think that's kind of a duplicate in here, but there's another concept that's what we call the CYA syndrome. And that's that you have to turn over every single stone in litigation so that you're not missing something. And we've all had that experience before. What if I missed something that showed that my client was entitled to significantly greater damages? Or what if I missed a document that provided the key defense to my client's claim? And then finally, actually not finally, I have one more, but there's client inertia. Clients are busy, in-house counsel are busy, and how in the heck can you get clients' attention within a 30, 45, 60-day time span? It's going to require a lot of effort by the client, especially in larger cases, to try and settle this. And most clients, quite frankly, aren't used to that. The ones who are experienced in litigation aren't used to that. I guess the last one I want to put in here is actually something that came up during the training last December in Toledo. And I think there was somebody in the audience who said, well, I want to write, my client and I want a jury trial, and this doesn't allow for a jury trial. I think we can go to the next slide. And our response, and this is Peter's slide from last year, our response to this is baloney. We think each of these points and others are addressed here. It's not our intent to demonstrate to you that this type of early dispute resolution is possible in every case. But with respect to the common objections we hear, we think the protocols provide some answers. So Peter, I'll turn it over to you for this.
Yeah. So legal profession inertia. You know, lawyers are tortoises and we live in a hare world. My guess is if you took somebody from 300 years ago, an English barrister, and showed them our modern federal rules of civil procedure and talked to them for about 5 minutes, they'd get it. They'd say, okay, I see what this is. I understand how this works. And we just don't change fast. So the idea that you could introduce a new mechanism to resolve disputes in 30 days, people say, well, it's just not going to happen. You're not going to change the way lawyers do business. But my sense is three things. There's two historical answers to that. One is mediation, which was introduced in the late 80s, and collaborative law, which was also introduced in the late 80s. I can remember in the franchise area where I practice, in the early 90s, the 8 biggest franchisors, so McDonald's, hotel companies, et cetera, got together and said, we like this new concept, mediation, and we're going to encourage everybody to do it with CPR. It was brand new and everybody didn't know. Today, it is just part of the system everywhere, completely accepted. Collaborative law, I don't think there's a collaborative law practice in Columbus, although I don't know that. In Cincinnati, there's a huge one. And the idea was it's a 4-way contract between client and lawyer on each side. All 4 of them sign a contract. It's in the domestic area. And the contract says if you don't resolve the dispute through this process, then you have to fire your attorneys. So if you go to court, you need new attorneys. And there's protocols for that, which helped inspire our protocols, but it's very cooperative. Parties try to get a common result. And there's now over 30,000 lawyers certified in it worldwide. And it's changed the face of domestic practice. And still has to come to some cities, but it's incredible service to clients. And I'm very high on it. So you can introduce change and it can come quickly. And then in terms of lawyers being in the tortoise world, around the time these things were introduced, you look at what was introduced that in those times that now dominate the world economy, right? The World Wide Web was introduced at that time. Amazon, Netflix, Google, Tesla, Facebook, iPhone. So lawyers need to change. Litigation is just costs too much and takes too long, and our clients aren't going to put up with it. And so we need to change, and I think it's going to happen. Next is the next objection that Mike mentioned was you need discovery. We all are concerned that, geez, we've got to find everything and find every document. But good lawyers who practice in an area know what's important. And right from the beginning of a case, you probably could narrow down and say, I really need to see this. I need to find this information. And then I can tell you what the value of the case is. There's no need for kitchen sink discovery. And then to test this, we did a survey. And when I looked last night, 6 of you had taken it. And so the results aren't statistically significant. But I'll tell you how you guys who took it, how you compared to everybody else. So what we did was we asked 3 questions. And it basically was trying to say, what's your confidence in forecasting? Because what your businesses make decisions all the time on limited information. And you get the limited information and there's a lot of uncertainty, but you have reasonable confidence you make a decision. So we're trying to gauge, well, how does lawyers' confidence work? And so we asked 3 questions. The first was, assume that you just get a case in and you look at the basic facts, you talk to your client, you give a call to the other lawyer, and how confident are you that you know where this is going to resolve, roughly where it should resolve, plus or minus 20%. And our results to date, and the results are remarkably robust. We've probably about 250 lawyers who have taken this, and about 60 continental lawyers. So they do not practice, they practice under civil law where there's no discovery. And the results were almost identical. It's really quite surprising. So lawyers on average had a 57% confidence level, just from when the case came in that they knew roughly where it'll end up. Then we said, what if you asked for a few key documents and said you might want to talk 5 minutes or 10 minutes with some of the key people and just ask them some questions? How much would your confidence go up? And it was 62%. Then we asked, what if you then did the whole case and you took full discovery and all the depositions and filed motions and got results, what would your confidence level be? And it was 64%. And so the punchline is this. If your lawyer, after this first, after the second look, right, the second question, you've done some basic follow-up and gotten some key documents, is 62% confident. And if you do all this discovery and all those motions, I suppose depending on the case, that could be another $50,000 or another $500,000. Your confidence only goes up 2%. Clients are crazy to pay lawyers to do that work. And if they understand this, they're going to say to lawyers, once you are reasonably confident where this should be, we want you to try to settle the case. That's the way we work as businesses. Now, the results for Columbus were 40% after the initial review, 50% after the follow-up, and 52% after all the discovery and motions. So punchline is the same. You get very little from doing all that discovery and motions in terms of confidence where the case will resolve, but at least the 6 who responded were more conservative than the average in confidence, which I will discuss later is probably a healthy conservatism. Mike, back to you.
Okay, thanks. Back to the greedy lawyer issue, or the lawyers who fear that they're gonna go out of business or significantly reduce their income. And our response to that is, you know, what world are you living in where you don't have clients that are constantly pressuring you on your fees and costs? They want people, they want budgets, they want people at a lower rate, they want discounts. And after you send the bill, they're always questioning, not all, but questioning what have you spent. And many of them are also evaluating the merits of these things on their own to say, you know, if I'm going to spend that much in litigation, why don't I settle it up front now? So I've seen that, and I think everybody's seen that. We think that once clients understand and learn about a quicker dispute resolution process, some already know this and do this, they'll embrace it. And we think that you'll be effective, more effective if you can adopt these principles in the right case. So the next slide, the doormat syndrome, I think everybody's had this before, that fear of broaching settlement first. And we think as you go through and you see these protocols, you will see some clear expectations that are set by the parties. And again, if you have somebody that's not willing to live up to these protocols, that's not committed to this process, it's simply not going to work. So we're not advocating that for cases outside of that concept. Go to the next slide. And 30 days just seems absolutely crazy for most disputes. Again, a lot of people can't or don't respond to complaints, including myself, in 30 days. We take an extension, we do other things. In 30 days, you might not even talk to your client in significant detail about the case. But you have to think about some other things that we do, and the perfect example is preliminary injunctions. A ton happens when you're preparing for a preliminary injunction. You have long hours, you spend a lot of time with the case, you do written discovery, you do depositions. So the notion that it can't be done in 30 days, 30, 45 days is just not true. We see that principally through items like case proceedings like preliminary injunctions. So you can go to the next one. Okay, so what if you ask the client the only real question? What is the only real question? That is, do you want to settle your case quickly and economically, or after years of contentious, expensive, time-sucking litigation where you and your client and everybody is exhausted and simply wants to move on? We think the answer for most clients is pretty clear.
I saw in the chat room there were a couple questions. One dealt with emotions. And so the basis for this, and I'm going to share a little bias I have on mediation. I don't know, I'd be interested in the chat room, maybe some of you could share how many are mediators or neutrals. So Sam and I are both neutrals, Marcus and Mike are not, although they might want to be into that, you know, move into that with this. But I'd be curious how many of you are. So in mediation, we know you've got to deal with emotions. And I think sometimes what we do as mediators is very manipulative. And that if we were to be honest with the people we're mediating for, we turn to the clients and say, here's what we're really doing. We're taught that you are very emotional about your case. And so we're going to spend a couple hours and ask you about your case. And if you're emotional, we're just going to encourage that. We're going to say, boy, it sounds like you were really angry about that. Or tell me more about why that hurt you so much. And that's what we're trained to do. And then you listen to that for an hour or two, and then you get the emotions out of everybody. And then you start working on them around lunch hour. And then you go back and forth and back and forth. And 3 or 4 o'clock, when you're completely exhausted, we as mediators try to zero in and force a settlement. It can be a manipulative process. This process is designed to allow people to focus on the merits and to give clients the information they need to make good decisions, and treats them as adults. So you'll see how that works when we go through some of this. The other comment that somebody had put in was the problem if you're doing PI work, that your meds don't come in quickly, and so you won't know for a while how damages are done. So the answer to that is probably you wouldn't start this process. You might agree to toll, and that you might say, as soon as I get my meds and the records, then let's start the process. And I'll share with you that at the training session was one of the people who attended was a head of litigation for might be the largest insurance company in the world. And he was blown away by this and just really felt that not for every case, but for many cases, this would be a very effective tool to use to get to where things go. I'll just add one more thing for those of you who are PI lawyers. Well, actually, we'll talk about that later when we talk about lawyer-lawyer relationships, because I think it's a problem where you get captive insurance companies. But I'm going to save that for later. All right, Sam?
Yeah, so Marcus, take us through the key concepts, if you would.
No problem. I believe, Peter, do you have something to add to this really quickly before we get to the next slide?
Yes, I do. So I talked a little bit about the protocols. I'll just say a little bit more now. They are long, they're very flexible, and you can apply them as appropriate depending on the complexity of the case. And you can get them on our website. We, in Houston, one of the Houston trial courts started an EDR pilot project, I think about 6 weeks ago, and so far the settlements have been just fantastic, but none of them have gotten into the details of the protocols. They've all been done quickly, just using the concepts. And so as you get to know the protocols, they're very flexible. But that's the first key concept in understanding this, that you should look and read the protocols.
Okay, now Michael and Peter went through the reasons why some people say EDR can't work. They told you why we think these reasons are baloney. Now I'm going to go through some of the protocols and discuss how they apply to the process and why EDR might not be right for every dispute. For example, Peter just touched on a moment ago regarding certain personal injury cases, if you're waiting on medical bills and other documents. So Protocol 2.2 addresses what we think are necessary conditions for the process to work. First, the parties have to be reasonable. Some clients don't want a quick and economical resolution. They just want to win or be right, like Sam said earlier. Or they don't want to cooperate with the other side because of, for example, as one of the attendees said, emotions are involved. People, they just don't want to cooperate. They want to have a scorched earth policy and just thumb their nose to the other side. If that's the case, then EDR shouldn't be used. Second, attorneys have to have 3 qualities. They need to be ethical, because there's a lot of trust required in the EDR process. And if the attorneys can't fully trust each other, the EDR process just won't work. The attorneys also have to be knowledgeable about the subject matter of the dispute. EDR requires the ability to analyze a case, come to a reasonable forecast of the outcome, have a high level of confidence about the outcome, and also do it on tight deadlines, 30, 60 days. If attorneys don't have experience in the subject matter, they won't be able to efficiently get through the process and just shouldn't participate. Attorneys should be also trained and skilled in the process. As Peter said, the protocols are lengthy. There's a lot to them. So people should know the procedures, be comfortable with them, or at least be willing to work and collaborate with an attorney who has some formal training in the EDR process. Or you can always bring in an EDR neutral, someone that can help guide the parties through the process and kind of be an intermediary for any disputes that may arise. Again, the process works best when the attorneys understand the protocols and the procedures necessary to facilitate the best outcome for their clients. You also have to have the ability to request only the sufficient information to get to the answer and to assess your case as well as your opponent's case. You only want to understand the strengths and weaknesses of each side and make an informed judgment about the value of the case. I think Peter touched on this earlier. This is not the time for the same old generic form discovery requests. You ask for any and all documents, all records pertaining to, relevant to, etc. You really want to be focused and direct in your information requests. Get to the point, understand the issues, and help yourself and your client make a reasonable forecast about the resolution of this case. This goes back, like I said, to being knowledgeable about the subject. If you thoroughly understand your industry and the relevant issues in the case, it'll help you request only the information that you know is going to help you make the right decisions for your client. There's also a requirement that the attorney has sufficient information and commits to a fair resolution. Now, this is a very cooperative process. It requires a lot of trust in the other side. We'll get to this later, but you want to provide information that at sometimes may not be or put your client in the best light. And so you have to be fair, reasonable, and ethical as you're going through the process. Under the process, EDR is a voluntary process. So you have to make your decisions based on all the circumstances provided. That involves taking a realistic look at all the facts, all the leverage factors, the probabilities of winning. All of that has to come into making an early and economical forecast of the case. This is all stuff that needs to be done early, but at the same time, you want to get it done before you've spent a pretty penny in litigation. One of the other concepts in EDR is the client's interest and not the attorney's egos. Protocol number 4, I think if we move to the next slide, Sam. Thank you. Protocol number 4 addresses the attorney's obligations to the client. Again, attorneys have an ethical obligation to educate their clients on the EDR process and disclose how it differs from what they may be used to in mediation or standard litigation. This includes letting them know both strategically and procedurally how the EDR process differs. Again, as I mentioned earlier, the client needs to understand that both sides will have to disclose information, even if it's harmful. Full disclosure allows the clients to make an informed choice whether or not to enter into the process. Like I said, it isn't for everyone. It works only for the clients who want a quick, economical, and fair resolution of their case. One key distinction between EDR and your typical litigation that especially needs to be told and explained to your clients is that zealous representation in EDR is not the same as it is in litigation. Usually, zealous representation in litigation is, like I said, a scorched earth policy. You're doing anything you can within the rules of civil procedure and the rules of ethics, to win the case. And sometimes that's what your client wants. They don't care what it's going to cost. Again, they just want to be right. They just want to win. But in EDR, zealous representation is different. It's still representing your client aggressively, but it's to get the best result, and doing so within the ethical guidelines and being cooperative. Like I said, the protocols require the cooperation of both parties in order to move the process smoothly in the tight timelines that EDR calls for. Next slide there, Sam. Okay, thank you. Protocol number 5 addresses an attorney's obligations to meet a heightened level of professionalism in dealing with each attorney and the other clients. Again, attorneys here need more soft skills like trust, decency. You have to be able to work well with the other side. There's tight deadlines, a lot of cooperation required. It helps if the attorneys, can work in a reasonably professional manner. Again, it's not the time for a scorched earth policy, and basically there's no need for jerks in this process. You don't have to go out of your way to be buddy-buddy with the other side, but you do have to maintain that decorum and a sense of being reasonable and ethical. Otherwise, the process just won't work. It's important for attorneys to strive for a higher ethical standard than the Ohio rules of professional conduct, especially as it relates to ethics and cooperation. Can't stress the cooperation part enough. We'll get into some of these ideas later on in the program with Peter, but again, the deadlines and the cooperative information exchange required for EDR to be successful. It's imperative that attorneys have trust and confidence in the other side. Otherwise, the parties should just move on to other means of resolution, maybe mediation, ADR, or just litigation in general. Everyone involved in this process has to buy in. So attorneys also need to commit that if they or their clients cannot or are not willing to comply with the higher standards, they'll simply withdraw from the process. Next slide, please, Sam. While the process does rely on trust, it does require that verifying that trust in an EDR agreement. The attorneys and clients sign before the process, and this agreement, it should lay out all of the deadlines and steps involved in the process. The parties can agree on these steps and the timelines prior, and it will help the efficient resolution of your issue. The EDR agreement, we can incorporate the agreement into a standard contract, standard business agreement. It can be a standalone EDR agreement by itself. It just depends on the situation and the level of communication with the parties before an issue arises. There's also Protocol 2.5. 2.5 specifies items that you should include in the EDR process. Again, if you have clients who do a fair amount of business with another party, and they think that this process might be something that, in the event of a dispute that they would be willing to look into, you can have your clients, go over the protocols, kind of agree with an ad hoc agreement that they can attach as an exhibit to any of their contracts. Specifically, these agreements, should go through the schedule of the process, any final mediation dates, the commitment of the parties to withdraw if they think they cannot fully perform any of the protocols and can't be cooperative and deal reasonably with the other side. Again, an EDR neutral or someone skilled or knowledgeable about the process can help you develop an agreement suited for you or your clients' complexity and business issues, and it will definitely help to get these things out of the way instead of waiting until an issue arises. Now I'll turn it over, believe it, to Peter.
Yeah, Peter, now that we understand the concepts, why don't you take us through the 4 steps and get into the meat of this?
I will do so. I saw somebody also posted a question about an earlier comment about collaborative law. And so there is a group trying to bring collaborative law to civil litigation. And I don't remember the website they have, but they are trying. And it's a very interesting concept. I tend to think there's some issues with it compared to domestic, but it's another very good alternative. And if you're interested, you can send me an email. I will find the website for you. And there's some folk. There's a guy in North Carolina named John Surratt, who's the current president of that group.
Peter, are you thinking of the Global Collaborative Law Council?
Yes, I am.
I'll send out a link to it on
Great.
the answer.
Okay, thank you.
You bet.
All right, so just kind of brass tacks. How does this work in 30 days? And here's roughly a 30-day schedule. Now, again, you don't need it to be wedded to 30 days, but this is roughly what it would look like. I've done it in business days. So you could take 6 days for the initial dispute assessment, which we'll explain. Does take some time. 8 days for the information exchange, which takes time because it's like limited discovery. Objective dispute valuation, you should be able to do in a couple days if you're good at this and you're skilled in the area. And then the final resolution process would leave 6 days. And at the end, if you have not resolved it, you set a mediation for day 30. And the neutral could actually do the mediation. But ideally, you'd get it done before then. So neutral. We mentioned using a neutral. What does a neutral do in this process? First, the neutral guides each step. So ideally parties, so we've trained now and we've got our certified neutrals up on our website, a number of people in this. And if you were to do this, you'd call an EDR neutral. They might help you negotiate your EDR agreement with the other side. And then they'd actively help guide you through in each step. This should be cheaper than mediation. It may be just a couple hours by phone that EDR neutral needs to help each party. And now we're all so much used to video, it's even going to be easier and more accepted to use that. But facilitation. So in the final stage, the parties do negotiate, and the mediator can help facilitate that, or if it gets to 30 days and there's no resolution, do an actual mediation. The final skill for the EDR neutral, if the dispute doesn't resolve, they help craft an expedited, economical, binding procedure to resolve the dispute. And we'll get into that. That's protocol 10. But the idea is, even if this process doesn't work, you can devise some way to keep on going and get it resolved quickly and inexpensively. Protocol 2.2. The basic idea in rapid, simple resolution is, once you're familiar with these concepts it's very easy to go in with a phone call and just talk to both parties and see whether you can resolve this quickly. So let's say it's a non-compete case, and you really need to know, did my employee take our customer list? And you might say, well, we'll give, what about if the other side gives you an affidavit and you can take a 30-minute deposition? You might say, okay, that would help resolve it, and it might be resolved. So before going through the full process, you should always do this step. As I said, in the Houston pilot project, the EDR neutral has resolved everything through the rapid simple resolution process. It's a little frustrating for us because we wanted to get data on going through all the steps and everything, but it's so far been very effective. At some point, the judge and the neutral are going to write an article on the initial results from the pilot project, and that'll go up on our website. Initial dispute analysis. So we all look at a case and try to figure it out initially, but here this is a very specific requirement. So the first is a no surprises investigation. So you go to your client and let's say it's a non-compete case, and you hired this person, and we say to her, well, did you copy anything, blah, blah, blah. And she says, geez, I don't think so. And of course, as a lawyer, you hear, I don't think so, she copied something, right? But you think, okay, I'll press her at some point. I know there's an issue here. The idea in EDR is you say to her and everybody else, look, you can tell me this now, or you can tell it to me in 9 months after the client has spent hundreds of thousands of dollars. They have tons of documents, and they sit you down for 6 hours in a deposition and grill you. So you might as well tell me now so we get the facts out. So that's a no surprises investigation. You have to identify the dispositive issues. That does not mean you need all 16 issues that we lawyers put in complaints, right? It's breach of contract, breach of the covenant of good faith, and it's unjust enrichment, and blah, 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 blah. You just need what are the key issues and to focus on those. Sufficient knowledge. You need to say to your client, think, is there anything we need to know about the other side to value this case? And if it is, let's define it narrowly and let's get it now, and then we can value the case. The fourth part of this is you have to determine whether you want to use an expert. And so if you want to use an expert, there is a procedure in here for doing so, and it will take a little bit longer. So that's a key decision you have to make right from the beginning. The sufficient knowledge request. So you've talked to your client, and hopefully you narrow down what it is you need to see. Now, we as lawyers are horrible at this, and it's because we're used to covering our own rear ends, right? If we get $25,000 in ESI and read every one of them, one, it's very lucrative, and two, no one's ever going to say, oh, you didn't overturn this rock. And so this really requires you to know your area. Because if you know your area, you'll know what's key, and you'll know what you don't need to do. And in this, you can ask for documents, or you can even ask to interview the other side. Or you might say, I need to talk to the other side and find out who is involved in this, what their documents were, and then I can figure out what to ask. And you say, I want 10 minutes with the person. Now, most of us as lawyers would say, no way are we going to let you talk to our person for 10 minutes. If you want that, you can talk to them in a deposition. That's foolish. Why is it foolish? Because you want to resolve the case early. Then your witness in the 10 minutes isn't going to say anything that they won't say 9 months later, and you might as well get it out. The other side should understand who's involved, what kind of documents are involved, and then can make a narrow request. If you're the EDR neutral, you have to be prepared to push both sides to narrow their requests, because it's just so tough for us to not leave any stone unturned. And if it gets too much, then you're doing full discovery, and then the process just doesn't work. So this is a big area for EDR neutrals. Now the question becomes, well, how do you know the other side's going to give you what you want? So in my case about, you hired away my chief marketing officer, and I think that my chief marketing officer took all our prices and all our customer list. You say, so just tell me, do you have it? And if you have it, let me know it. How do you know that the other side's going to cough that up? One, you don't. But even in discovery, you don't know. Even in federal court discovery, you're depending upon the integrity of the other party. And so you've got a federal judge, you've got other things that helps you and gives you some more comfort, but ultimately you're depending on their integrity. Here, what we've developed is what we call a compliant response. And we've got a specific protocol on this in Protocol 6, where a lawyer should respond in writing that I've made a reasonable request, I've made a reasonable search and produced reasonably responsive documents, and I didn't try to parse the words in your request. And our feeling is that if a lawyer does that and they are ethical and participating, that it should work. But this is a big thing in terms of getting clients to understand if the other side asks, you have to give up the information. Next is sufficient knowledge experts. Let's say, Mike does environmental work, right? A lot of times you need an expert. And so you might say, well, we need to test certain material to see what's in it. Maybe to see whether our products are in it or whether it came from somebody else. And so if you know right from the beginning that's a key issue, you might say to the other side, look, we've got to do that. And then what you could do is you both could hire an expert that would do an independent study, and you could both work on that, or each side could do an independent study. And what you'd say to your expert is, all you need to do is give me a one-page conclusion and some key facts. You don't need to give me a 50-page report. And both sides do that, and you can see what the key information is. The reality is, when most of us hire an expert, we know what that expert's going to say. Now, we might be hiring somebody who sells their opinions. Generally, that's not a good idea, but oftentimes you go to an expert and you say, look, assume these facts. What would be your opinion on why? The expert say, based on those facts, my opinion would be this. And if that's consistent with what you want, you would hire them. So they don't need to know everything under the sun. They know that from your first conversation. And you can make this without prejudice. So if you do get into trial later, the expert's sufficient knowledge report doesn't come in and somebody can't say, well, that was your initial conclusion, what changed, etc. And you need to build in timing for that. Third step is objective dispute valuation. So here somebody asked about emotions. And this process is designed to not manipulate emotions, but to try to get people back to thinking logically about their case and allowing them to make reasonable decisions. And so what we're going to do is we'll go over the factors we require people to balance. And then we're going to talk about the skill of forecasting, which is how you forecast what a reasonable result is. Part of that is we'll think of fast and slow thinking, which deals with biases. And then we'll talk some about risk analysis, statistics, and decision trees. So Sam, how are we doing on time here? This stuff gets a little dense from here.
Yeah, yeah, Peter, I was about to send you a private chat. We're 54 seconds away per slide. If you use, if we finish at 1:15, and you got 1 minute and 40 seconds if you finish at 1:30.
Okay, so we're roughly on target.
We're a little behind.
Little behind. Okay. So this stuff gets dense. You're going to have the slides. And so you'll be able to go back to the slides. And if you have any questions, you can send that to us. But I do want to go through it all so you get a sense of what the full training would be. And if there are any professors in the group, I saw somebody, I know we have at least one neutral. This is an area that law schools do not teach, that is an essential skill for lawyers. And there's tremendous research that can be done, and there's law school courses that should be taught on this because these are skills all lawyers use and they aren't taught. So Protocol 8.1 talks about integrity and sharing. So the idea is that if I'm a client, I want to know what my case is. I don't want an attorney who's going to beat their chest and say, I'm the best in the world and we're going to club the other side. I want somebody who's going to give me an objective assessment. I also want to hear what the other side does. So as a lawyer, whenever I go into mediation, I tell my clients, one of the best parts about this is I could be wrong. And you're going to hear the other side's position. And if we hear it and we learn something, that's good. And so this gives you another chance to do that. And so when you get these factors on the table, they can serve as the basis for meaningful negotiation that's hopefully based on the merits and not on the emotional factors. We have a protocol that says these are what you have to set out for an EDR neutral. And if you're being a neutral, you ask parties to do this. Now, I found as a mediator, I regularly ask people to do BATNAs and WATNAs, which I'll explain a little bit, and they never do. And lawyers just aren't good at this. So this requires lawyers to be very sophisticated in forecasting, which is what we should do as professionals for clients. First, we do the future costs for each side. Past costs are irrelevant because they're sunk. Future costs are how much you're going to spend to take this through trial. What's your percentage likelihood of prevailing on dispositive claims? So this goes back to stage 1, where you have to identify your key claims, not the 15 you put in your complaint or your 23 affirmative defenses. It's the 1 or 2 key issues and claims. What do you think your percentage likelihood is prevailing on that? And why do you think that? And you've got, as a lawyer, to become sophisticated with what a percentage means. We'll get into this a little bit more, but basically, percentage likelihood means if this case was tried 10 times, and I think there's a 50% chance of winning, you would win 5 times and you'd lose 5 times. You only try it once. So in using this, you've got to explain to your client what it means, how it turns out, and you've got to give them a real number, not we think it's highly likely, reasonable chance, etc., which are much words. You give an actual number. Damages. I find as a mediator and even as a lawyer that lawyers are horrible on damages. We look at basically our high end, and then we don't do much thinking about how the other side's going to chop that down. So this says to each side, give me your low, middle, and high range of what you think damages would be. Then you get the likely statistical result, which is basically you multiply the percentage likelihood times damages, and then you subtract future costs. And that gives you the likely statistical results. And I'll give you a slide on that. BATN is your best alternative to a negotiated agreement. WATN is your worst alternative. So you help see parties to understand what their brackets are. What's the worst you can do and best you can do. Leverage factors. If I have, if I'm representing Bill Gates and I'm going against a small business that doesn't have much money, I can spend them into the ground. That's fair game. And so you would bring that up in assessing the case. And why is it good to bring it up now? Because if I'm the small company and the other side knows they can spend me into the ground, we might as well discuss that now rather than in 9 months after I've spent all my money and what's obvious to everybody has already occurred. And then interest-based solutions, which is basically win-win type solutions, which can happen when you have ongoing relationships and the like, but most lawsuits are over money and damages, but that you should lay all of these out. I'm going to go through this slide. When you get the slide, you can go through the math. But I'm just trying to show you what statistical result means. And this goes very fast, and we don't have the time to really get into it. But this is how it works. So John sues Sally for breach. If he wins, he gets $250,000, and if he loses, his damages are $0. So I've simplified damages here. I don't give a range. He's got a 50% chance of winning. They've each spent $5,000 on fees with their lawyers threatening each other. They'll each spend $75,000 litigating the case through award. Those are the basics. Now, as a lawyer, you might think, well, okay, how do we do this and figure out what a reasonable range is? And when you look at statistical results, it becomes a little more interesting than just saying, well, split the difference. So for John, his likely statistical result is half the time he'd win $250,000. So it comes out to 125, but he's going to spend 75,000. So his likely statistical result is he'll go through this and end up with $50,000. Now, if John understands that and understands the math, he might be more reasonable in settlement. What's Sally's likely statistical result? She's got a 50% chance of losing $250,000, which would be 125, and she'll spend 75. So her likely statistical result is a loss of 200. All of a sudden, both sides get a lot more reasonable in discussing settlement. And then you look at their BATNAs and WATNAs to give them more context on how well or not you could do. John could end up losing $75,000 on this, right? He goes to court and he loses. He loses $75,000. The best he's going to do is $175,000, right? He wins $250 and spends $75. And then you do Sally's WATNA, or worse, she loses $250, she loses the $75. She's down $325. Her BATNA, I've got a typo there I got to fix, is $75,000. The best she does is take it all the way through trial and loses that. So all of a sudden you put these numbers on the table and you've got a lot more to work with as a neutral. And as a lawyer, you've given your client the information they should have to make a good decision for them. And if they don't get these numbers, we have not done them a good service. Step 4 is you've got all that out. You've got all this on the table. And then you can help the parties negotiate because they now can negotiate with real numbers. Or you have a mediation on day 30. You may get through all of that and there's still an issue. Let's say in a non-compete case, maybe the issue is what the word solicitation means. You can't solicit your clients. And the question was, well, if the client calls, if you send out an announcement that I'm going to another company, is that solicitation? And that may just be the only difference. One side says, I've got a 75% chance of winning on that. The other side says, I have a 75% chance of winning. You as a neutral can't get them to budge off that. And there might be good faith basis for it. So you might say to them, okay, let's set up a procedure. We'll give an arbitrator these basic facts and we'll pick them, and within 3 weeks, we're just going to present the arbitrator that decision, and then you could make it baseball. If the arbitrator decides this was solicitation, damages are X. If the arbitrator decides not, damages are Y. And it might be night baseball. The arbitrator might not know what they are. But both parties, by getting all this discussion, doing sufficient knowledge discovery, should not have the need to go through full discovery, and hopefully you can work them through a binding process. So that takes you through the 4 steps, and that would be the procedure. Now, let's see, it's 2:10. And so if we want questions, Sam, that means I've got 5 minutes to do this. You're on mute.
Yeah, we have 5 minutes.
Okay, so here's what we're going to do. I'm going to go through this very quickly, and I'm going to try and stop at 2:15. If people don't have questions or there's not discussion, we can go back and do this with some time. This takes roughly 1 of the 2 days, and lawyers find this very interesting and they really enjoy it because it has applications across everything we do. So first, forecasting. One is we're lousy forecasters. Which is why I said maybe it's good for the Columbus people to not be so confident. There was a 2000.
Peter, I lost your voice. I don't know. Did everybody else lose Peter's voice?
Yeah.
By an average of $1.1 million.
Yes.
So this is
Here he
cases
is.
there was settlement being discussed and they went to trial. So we've got a lot of work to do, and there's it could be discussed, interesting what this all means, but basically there's a lot of work to do. Next is, do you see my screen, everybody? Sam, is my screen still showing the full PowerPoint?
Peter, we lost
It's
your
not.
voice and the PowerPoint is gone, so I think you'll have to share your screen again. Your PowerPoint. We lost your voice as you went into slide 33, forecasting. Can you hear me?
Yeah, I can hear you.
Okay. Good.
Okay.
Right. Yep.
Okay. So so you missed all my brilliant comment about the skill of forecasting?
Well, you talked about how everybody, lawyers find this interesting across the board, and then we
Okay.
lost you.
All right, so now I've used up 2 of my precious minutes. Here's an article by a guy named Kaiser. People want to send me an email, I'll send you the link. Studied 9,000 cases and found that in California, where there were settlement offers, they went to trial and basically found that plaintiffs missed 60% of the time by $40,000. Defendants missed 24% of the time, but by $1.1 million. So there's a lot of work to do. Part of the work is thinking through heuristics. This is a new field in psychology, and basically the difference between fast and slow thinking. Fast is intuitive, automatic, emotional, the kind of quick snap decisions we all make all the time. Slow is deliberative once you start thinking. Lawyers and clients engage in a lot of fast thinking with with cases and settlement. And so as we learn more about this, we can learn to overcome it, and the process is set up to do that. These are all biases that impede settlement. And at the end, I'm going to give you an article written by a judge and a lawyer that set these out very well. But they're things that the protocols are designed to deal with. I'm not going to have time to do this framing. If we do have time, I'll come back to the framing slides because this is fun and I put you through a test. But basically, if you frame things as a loss, people are very risk tolerant. I'd much rather roll the dice to get 0 than have to agree to pay you something. And they tend to be risk averse weighing gains. I'd much rather take $100 than roll the dice to get 200. So that's why in the protocols we present multiple frames, WATNA and BATNA, get people to look at gains and losses equally. Confirmation bias, I actually have a wonderful story that I'm not going to be able to tell you, but basically every time you look at your case and new facts come in, the facts just support everything you've always thought. You don't look at them to see what how it could hurt you. And so that's why both sides are required to put down their percentages of likelihood of winning and explain why, to show both sides and your clients how the facts can be looked at differently. This is just each step goes differently. The sunken cost fallacy, any of you are mediators know everybody comes in and says, well, I just need to get my fees back plus X. It's sunk money, it's gone. Both sides want it, and the only thing's relevant is what you're going to spend going forward, which is why we do the statistical results. Anchoring, I've got another great story to tell, but we've all heard this, right? You start high and you try and get a number in somebody's mind, the other party starts low. It's actually much more sophisticated than that, but that's why we put a lot of numbers on the table. So there's no anchoring to big numbers. This I'm not going to really be able to get into other than to give you a little bit of an overview. And this just will show you how lawyers can't think about statistics. So here's a simple statistical thing, and I want you to write down on your piece of paper in front of you what your fast thinking answer is to this, okay? Because as lawyers will form judgments and they tend to stay in our mind. You've got 2 claims as a plaintiff. Let's say a fraud claim and a contract claim. You can win on either or both of them. Your odds of winning are 50% on each claim. So what are your odds of winning the case? Write down what you think the answer is, please. And I'm going to give you the answer. The answer is 75%. And it's 0.5 plus 0.5 times 0.5. And over here, I've got a little visual that shows you why it's 50%, depending on whether you win or lose both. Then you can also do it there's a sequencing You have a 50% chance of winning in your claim, a 50% chance on punitive damages. What's your chances of getting punitive damages? It's 25%. I'd have to explain that. The only thing that I think you can take from this is that there is a lot of learning to be done by lawyers in thinking through these issues. One way to do that is decision trees, and not one of these big, complex, long decision trees, but decision trees basically force you to think through each step in the process to avoid statistical errors. And you have to exercise a lot of judgment to focus only on the key issues, so you don't have a gazillion branches. This slide has 5 articles. And when you get it, if you want to read more, these are all excellent articles that you can read more on this. Also with the paper I sent you, I described some of this stuff, but it's not a lot in the paper. It's something I'm actually writing on now. Secret sauce, why does this work? We figured out the ethical standards that you can trust the other side. We've got carefully defined rules with safeguards, so your client's comfortable. You're not going to get taken by anybody. Requires skilled lawyers who can distinguish between wheat and chaff, and then use sophisticated risk analysis tools, which takes some education. If you get that, you're in hair world, and you can resolve cases quickly. So, actually, we're at 2:20. If people have questions and you have, can we open up their mics now so that people can ask, or could they raise their hands and then, I guess people might not see them. Can we do this, Judy, or no?
Yeah, I went ahead and tried to unmute all the attendees, so.
All right. Does anybody have questions? And we're glad to discuss them, or I could go back and focus on a couple of these slides I didn't get a chance to focus on.
Oh, B. Sowald had a question, but I can't enable remotely her microphone.
Yes.
Oh, we hear
there
her.
she is.
Okay. Are you on mine?
Yes.
We can hear you.
We can
Oh,
see
okay,
you and
fine.
hear you and see the beautiful
My question
painting
is-
behind you.
My question is, how can you mediate or do this if the other attorney is not willing?
So this process is not for everyone. And if you have one party who isn't willing, this is not a good process for it. Over time, my goal and the goal of the Early Dispute Resolution Institute is to begin to educate clients and business owners about these tools. And so hopefully people will not hire lawyers who refuse to do this, because lawyers who refuse to do this generally want big fees. And also, I personally would like to see an ethical rule that requires lawyers to inform their clients about ADR and how you can resolve disputes economically and quickly, so clients can make decisions. And I think once clients are educated, they'll want to do that. So that's my answer, B. I don't know if it's not the magic wand that you wanted, but that's my answer.
Thank you.
Beauty, any other questions?
Yeah, Peter, this is Sam. This
Yeah.
isn't a question, but I'd like to just add to that. You know,
Yeah.
I think as this concept makes its way, and of course we know that the family lawyers have been doing it. You know I practiced in California for years, and it was catching fire out there, like you said, in the late 80s and early 90s. I left there in the mid 90s, but I knew quite a number of collaborative lawyers at that time, and now it's a big deal out there. and I assume it is everywhere. I don't practice in the field, so I don't know. But you know, the buyers of legal services are going to learn about this, and when they do, they're going to want it. And so I think, you know, I think the sooner lawyers learn as much as they can about it, so that if they have a client that actually comes to them and says, look, I want to find a better way, you have something to offer that you really truly understand. And I mean, sure, it has its limitations, but it's a great idea. And there are some great, these protocols are wonderful. They're well thought out. They're flexible. You know, the two lawyers or group of lawyers that, you know, I can't imagine three lawyers agreeing on anything, but two lawyers at least could get together and you know, fashion an EDR agreement tailored just to that dispute using these protocols. And, you know, nothing's locked in cement. That's the more you know about it, the more you'll realize how it can serve your clients.
You know, here's another thing. Some of you might remember Michael Banger from the Supreme Court. He wrote an article, I forget the name, about that courts should have lots of doors. And the idea is right now, there's only one door you walk through, and that's the trial door. And his thought is we should offer people more options. And so in Houston, we're doing this as a pilot project. But I would like to see the point where our courts get to the point where somebody files this. For example, they could choose an EDR option. They could say, I'm going to go under these rules, and it's going to take 30 days. And if, let's say that 30-day example I gave, if after day 30, there's one question: what does solicitation mean? If I send a letter out to all my customers saying I changed, but I don't say, bring your business with me, is that solicitation? The judge might say, if that's your only question, I will give you a hearing in 2 weeks and you'll get a decision. So all of a sudden we're offering consumers justice. And one of the real problems with litigation, I'm sure everybody has it, is somebody comes to you with a case for $25,000. You say to them, geez, nothing I can do. You're going to spend more than this. And we have to find ways to make justice available to people like that. So I'm very bullish on this, and very bullish to courts opening their minds as to new ways to approach this, because it's tough now, very tough to get through the court system.
Well, I'd just like to add, speaking as a mediator, it's frustrating, and you know this, Peter, or anybody who acts as a mediator knows it's frustrating when you get to a mediation and realize that the parties just don't have enough information, and you thought they would, you were assured they would. That's one question I ask always in a pre-mediation conference: do you have enough information for decision makers to make decisions? And you know, this process helps that a lot. And you know, I have a case going right now where I think the parties are working hard together and coming up with discovery, and I don't think they're going to even need to mediate with me. So you know, I touch base with them every once in a while, and that's the way it should work. You know, it's the way it should work for clients. It's the way it should work for the lawyers if they're just committed to the idea of doing it in a sensible, non-judicial way.
Judy, any other questions from the crowd?
There are no other pending questions.
All right, so I said there was a couple slides that I thought would be fun for people where I could ask some questions. Oh, the framing. All right, so here's just a fun one when you get into these. All right, so I want you to write down your answers. So the question is, you're offered $100 for sure. I'll give you $100 bill. or I'll give you a 50% chance to win $200. Write down which one you want. This is a test that's been given thousands of times across the country. Next, I offer you something different. I say you can either have two choices. You can either give me $100 or we'll flip a coin, and if you win, it's 0, and if you lose, that should be $200 rather than 200,000.
It's a no-brainer.
Yep, another typo I've got to deal with here. Which would you rather do? Now, both of these, if we're rational economic actors, are equivalent. It's a 50-50 shot, and you'd think people would view them the same. But the studies show that people don't want to give over that $100. It just kills them to give over that $100. And so they'd say, I'm willing to take that chance. But if they can put $100 in their pocket, they tend to say, no way am I going to roll the dice. Give me the $100. And so that's just the way people think. And if you're neutrals, of course, you can use this to manipulate people. I don't think we should do that. But if you use this process and put these objective factors out, you allow clients to look at it both ways. And it helps kind of balance this and allows more rational thinking. So that's just a fun one. So it's almost 2:30. Judy, you need a wrap up, or are we going to 2:32, or how's this working?
If you have 2 more minutes to talk, that's fine. I can wrap up now. I will just tell you that I don't have any pending questions either.
Okay. Of course, I could talk about this stuff forever. Well, why don't you wrap up? And anything I say it's not gonna add much now.
Peter, can I just ask you a quick question?
Yeah.
Say when you are going to try to do the next 2-day training on this?
So right now I'm working on trying to see if we can do this on video. And if so, we'd probably start offering it in the fall again. But as you can see, it's very dense stuff and it works very well in person. And I've got to figure out how it's done in video. But if you go to the website, when we do it, we'll put it up. And it's kind of thing that if you need a group of lawyers. That's what they learn in collaborative law, where there's a cluster of lawyers that works very well. Anything else, Marcus or Mike, that you wanted to say?
Peter, I'll add one thing. I know that one thing I found very effective at the one I attended last December was the work groups within the group. Small work groups where we worked out problems.
Yeah,
that was very valuable.
Yeah, this stuff just takes processing. But we're trying to. I mean, I've become very sophisticated at Zoom. I'm sure all of you have. 2 months ago, I was an idiot. So there might be a way to do that now, and we're looking at how to do that.
Breakout rooms.
Breakout rooms.
Yeah. Zoom mediation. Zoom mediations are working great for me with the breakout rooms.
Yep. Marcus, any last comments?
No, other than thank you for letting me join. I really, like Sam said, really enjoyed the 2-day event last December. I think, like he said, having a group of lawyers and them giving their experiences with the program, both pros and cons, was very valuable. I also think this is a wonderful process for certain situations. And if you can find those situations, it can really cut through a lot of the unnecessary paperwork and motion practice that a lot of clients get caught up in.
The straight line.
Also, Pete, would you like to show the contact screen at the end in case anybody has questions for Someone in the group?
Nope. Can you do that? Oh, let's see. I just lost this again somehow.
Just scroll down on the left side, Peter. Just scroll. There you go. There you are.
All right. So we're going to go ahead and wrap up this event today. If you have any other questions or want to ask these amazing instructors about anything after you think about it that they presented to you today, please make a note of their contact information. If you lose their contact information, contact me, I have it, and or go to their various websites. I want to thank everybody involved in this particular program today. I really did sit and listen to every word of it and learned a lot. For those of you who are participants, I will report your attendance at this event within 30 days. There is nothing else you need to do to get your attendance reported. Thank you very much, and we will see you at the bar.
Thank you, Judy.
Thank you.
Thank you.